Felicidad Uy, Petitioner versus Honorable Maximo C. Contreras, Presiding Judge, Metropolitan Trial Court, Branch 61, Makati, Metro Manila, Honorable Mauro M. Castro, Provincial Prosecutor of Pasig, Metro Manila, Susana Ataide and Winnie Javier, Respondents. GR number 111416, September 26, 1994. The facts of the case. Petitioner Felicidad Uy, Uy for brevity, subleased from Respondent Susana Ataide, Ataide for brevity, the other half of the second floor of a building located at corner Reposa and Aliman Streets, Makati, Metro Manila. She operated and maintained therein a beauty parlor. The subleased contract expired on 15 April 1993. However, the petitioner was not able to remove all her movable properties. An argument arose between Uy and Ataide when the former sought to withdraw from the subleased premises her remaining movable properties. The argument degenerated into a scuffle between the petitioner, on the other hand, and Ataide and several of Ataide's employees, including private respondent Winnie Javier, Javier for brevity, on the other. The private respondents filed a complaint with the barangay captain of Valenzuela, Makati, and the confrontation of the parties was scheduled by the barangay captain. However, only the petitioner appeared. The barangay captain then reset the confrontation. Prior to the confrontation, the Office of the Provincial Prosecutor of Rizal filed two separate information for slight physical injuries against the petitioner with the MTC of Makati. Judge Contreras ordered the petitioner to submit her counter-affidavit and those of her witnesses. Petitioner filed a motion to dismiss for non-compliance with the requirement of PD number 1508 on prior referral to the lupong tagapamayapa and pursuant to Section 18 of the 1991 Revised Rule and Summary Procedure, specifically alleging the prematurity of the filing of the criminal cases for failure to undergo conciliation proceedings, as she and the private respondents are residents of Manila. She has also attached to it a certification by the barangay captain of Valenzuela, Makati, dated that there was an ongoing conciliation between Ataide and the petitioner. Judge Contreras handed down an order denying the motion to dismiss, stating that the complainants may go directly to the court, where their complaint is about to prescribe or barred by statute of limitations pursuant to Section 6 of PD 1508. The motion for reconsideration was likewise denied, hence the special civil action for certiorari. The issue: whether or not the case should be dismissed for failure to comply with the prior referral to the lupong tagapamayapa requirement pursuant to Section 6 of PD 1508, now embodied in Section 412 of the Local Government Code of 1991, and further required under Section 18 of the 1991 Revised Rule and Summary Procedure. The ruling: yes, the precise technical effect of failure to comply with the requirement of PD 1508, where applicable, is much the same effect produced by non-exhaustion of administrative remedies. The complaint becomes afflicted with the vice of prematurity. The controversy there alleged is not ripe for judicial determination. The complaint becomes vulnerable to a motion to dismiss. The court emphasized the vital role which the revised Katarungang Pambarangay law plays in the delivery of justice at the barangay level, in promoting peace, stability, and progress therein, and in effectively preventing or reducing expensive and wearisome litigation. Parties to disputes cognizable by the lupon should, with sincerity, exhaust the remedies provided by that law. Government prosecutors should exercise due diligence in ascertaining compliance with it, and trial courts should not hesitate to impose the appropriate sanctions for non-compliance thereof. Highlights of the Katarungang Pambarangay Law as cited in the Local Government Code of 1991. The first feature has necessarily broadened the jurisdiction of the lupon, and if the mediation and conciliation process at that level would be effectively pursued, few cases would reach the regular courts, justice would be achieved at less expense to the litigants, cordial relationships among protagonists in a small community would be restored, and peace and order therein enhanced. The second feature, which is covered by paragraph D, section 409 of the Local Government Code, also broadens the authority of the lupon in the sense that appropriate civil and criminal cases arising from incidents occurring in workplaces or institutions of learning shall be brought in the barangay where such workplace or institution is located. That barangay may not be the appropriate venue in either paragraph A or paragraph B of the said section. This rule provides convenience to the parties. Procedural rules, including those relating to venue, are designed to ensure a fair and convenient hearing to the parties, with complete justice between them as a result. Elsewise stated, convenience is the raison d'être of the rule on venue. The third feature is aimed at maximizing the effectiveness of the mediation, conciliation, or arbitration process. It discourages any intentional delay of the referral to a date close to the expiration of the prescriptive period, and then invoking the proximity of such expiration as the reason for immediate recourse to the courts. It also affords the parties sufficient time to cool off and face each other with less emotionalism and more objectivity, which are essential ingredients in the resolution of their dispute. The 60-day suspension of the prescriptive period should spell the difference between peace and full-blown, wearisome, and expensive litigation between the parties. Finished. The end. Special thanks to my professor, Attorney Alex Concha Tejerero. Thank you for all that you do for us, your students. I have learned so much in your class, albeit an asynchronous one. This has been a great semester despite the pandemic. May God bless you always, Attorney. Thank you.